All rise. The Court of Appeals Division 1 is now in session.
Good morning. You may be seated. So we're here today on our case number 1CACV160762, Spahn versus Maricopa County Treasurer. So counsel, as you likely know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself, because the clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if, when you approach the podium, you would give us both your name and the name of your client. We've read the briefs in the case. We reviewed the record from the trial court, the voluminous record. We've also discussed the case in our conference. So with that, you may proceed.
Brian Stanley for the appellant, Your Honor, and I'd like to reserve 10 minutes for rebuttal. May it please the court, the key issue in this case can be found at, page 5 of the appellee's answering brief, where the appellee would read, Fredina is saying that the county cannot be held liable for actions of the treasurer when those actions are based on statutory duties and are not subject to county oversight. And in the context of this case, that they must mean that under Fredina, the county is not liable for the refund of taxes paid under protest. Now, the statutory duties of the treasurer are numerous. He is the custodian of all money belonging to the county. That's ARS 11491. All public monies shall be paid into the treasury of the county, and the county treasurer shall apportion and apply the same to the several special and general funds as provided by law. That's ARS 11492. And by the way, for a brief excursus here, there is no special fund for the contingency of having to pay a redeemed CP holder, the holder of a redeemed CP under 42-18-155. You know, there are several special funds defined by law that the county treasurer is to apportion money into, such as the county expense fund established by the Board of Supervisors every year. But there is no special fund for this this kind of money for this contingency. It just is in the general fund of the county treasury.
You know, Mr. Stanley, may I interrupt to ask you a question? I want to make sure we get to it before your reserve time. If we go your way on Fredina, then the only issue, I take it, is whether on summary judgment there's a disputed issue of material fact about whether the county has been unjustly enriched.
Not exactly, Your Honor. The theory, the real theory, if this case had been brought to me when I was preparing the complaint, the first claim would have been money hadn't received.
What? I don't find that anywhere. What is that, a tort?
No, Your Honor. If you just search money hadn't received in Arizona cases, you will find it many places.
What's it now called?
It's simply a claim for money, to return money that the recipient didn't deserve to get from the payer.
You're saying if you had started the case, but in terms of how the case has been argued and what's now before us, I'm reading your brief as making a claim of unjust enrichment. Is that an accurate way to portray how you've briefed this?
Well, yes, because it's the alternative. Alternative pleading is the rule. Interpreting pleadings to do justice and making a final judgment that's based on the law and facts presented, those are all part of the civil rules too. So the fact that the words money hadn't received, which are old-fashioned, actually the full title of the action is an action of trespass on the case for indebitatus assumpsit for money hadn't received.
What's a case that says that that's a valid claim absent the elements of unjust enrichment?
I believe there are a number of cases cited in the opening brief which are Arizona money hadn't received cases. I mean, it's just a phrase you find when you search. It's a recognized cause of action.
Well, that's
and
my
it's,
point.
It's, pardon?
What cases recognized it in Arizona as a cause of action, absent the elements of unjust enrichment?
Okay, there's Hewish versus Lopez, 70 Arizona 201. There's Brainerd versus Walters, 85 Arizona 60.
And are you saying you made this claim below money?
The term of art, money hadn't received, or the full term of art, trespass on the case for indebitatus assumpsit for money hadn't received, certainly was not used below. But
the term unjust enrichment?
This court recognized in the previous appeal that this is an action by Mr. Spann for the return of money he paid under protest. That is, by its nature, an action for money hadn't received, an action for money that was paid that wasn't owed. I mean, if you overpay your tailor because you read his bill wrong, and then he refuses to give you the money back, if you sue him for that extra money you paid him, that is an action for money hadn't received.
Isn't it also an action for unjust enrichment?
It may also be an action for unjust enrichment, yes.
If that's what was addressed below, can we address something other than unjust enrichment?
What was granted below was a motion for summary judgment based on the Fredina theory. So,
but there was also the denial of a motion for summary judgment based on unjust enrichment. Is that right?
True. But as I say, I do not believe that the Superior Court, in granting a judgment one way or the other, is limited to the word terms of art that were used by the pleader in describing his claim. It's the facts of his claim that gives rise to one cause of action or another, but whatever cause of action is appropriate for granting a just judgment is the cause of action that can be and should be acted on by the trial court. In any event, the unjust enrichment was explicitly addressed below, but it's not appropriate to disregard the alternative theory of money hadn't received.
What are the elements of that claim?
The elements are a payment by a payer, either by mistake or because of an unjust demand. Money transfers hands. Money is in the hands of the recipient that the recipient was not entitled to. Indebitatus assumpsit, the ancient theory was, well, there's an implied promise to repay the amount overpaid.
You've suggested that there was an unjust demand. Doesn't that turn it into unjust enrichment?
It could.
Well, So why would we need to address something other than unjust enrichment? If there's that element.
If unjust enrichment is the basis for granting the plaintiff's appellant's claim, then nothing else needs to be addressed.
But if it's the basis for denying the claim, we're wondering if there's some other theory that has different elements. But you're suggesting that this other money had, and well, sorry, I can't remember the term. If that includes a requirement that there be an unjust request for the money, it sounds like the elements are are similar to unjust enrichment.
I guess in the broadest sense that whether even if he hadn't requested it, if your tailor hadn't sent you a bill for $500, he sent you a bill for $50, and you misread it and send him a check for $500. He's enriched to the extent he has something more than he's entitled to, but he made no unjust demand.
Right, but it's unjust for him to be able to keep it. So it
Yes.
sounds like it's the same.
Yes.
It's essentially the same as unjust enrichment.
To that extent, Your Honor, yes.
Why don't you address unjust enrichment? Why is it unjust? In this case, in your brief, you note that it was at least questionable whether the certificate purchaser was entitled to the redemption money under the statute. And it seemed like there was an argument that he was entitled to money. He'd paid the certificate. The lien wasn't valid under the terms of the statute, but he hadn't received notice. He had purchased it long before the new statute went into place. And you're acknowledging that it's at least questionable and that the county may have been obligated to pay him some money. So what's unjust about
that argument? I use those terms as a way of reinforcing the point by understatement. It's more than just questionable. The statute not only says that the certificate of purchase is invalidated, but that the underlying lien is void. So that means the statute requires the treasurer to make that payment under certain conditions, when proper demand is made by the CP holder and when the CP holder tenders the certificate of purchase. Now, we believe that implies he tenders a valid certificate of purchase, not one that's been expressly invalidated, as this court ruled in the previous opinion in this case, and which under the statute, therefore, evidenced a void lien.
Even if we assume it's invalid, does that necessarily tell us that the certificate purchaser wouldn't have had a claim against the county or against your client for unjust enrichment if the county neglected to send out a notice? The statute changed. When he purchased the certificate, there was no statute of repose, no statute of limitations. He could have hung on to it as long as he wanted. It was changed. He wasn't given notice that there was a change. Assuming he may have had a claim against them, but even if he didn't, would he have a claim against your client for unjust enrichment?
No, he would not. He had the ability to bring the foreclosure action. He had for 10 years after he purchased the certificate of purchase, and he lost that not by any action of my client, but because he didn't take any action within those 10 years. And indeed, as I said in my brief, you could say, well, that's not fair. If on one day he could have got his money, and the next he couldn't because the 10 years had passed. But that's what a statute of limitations, a statute of repose means. To that extent, the policy of the law maybe impose unfairness. It does every day. People lose their right to sue for terrible medical malpractice because 3 years have passed as of midnight last night. That's the policy of the law, and therefore it can't be regarded as, there would be no claim against my client. Or against I don't know, whether the county failed to give some notice that it should have given, that would be between the CP holder and the county. But that would be a separate mistake on the county's part. It's got nothing to do with the situation where absent some failure to give notice if notice was required, the county got the money twice. As of the time that Mr. Spann paid the redemption under protest, it had the money from the original CP holder. The CP holder had paid the subsequent year's taxes. All that money was paid. And then Mr. Spann paid it over again, plus interest.
What was the nature of the payment under protest that your client made? How did he do that?
You mean by check or?
How did he indicate he was paying it under protest?
I'm not sure. I haven't considered that an issue because it's stated in the previous opinion that he did pay it under protest. So I'm taking it to be the law of the case.
Your client could have avoided all this, couldn't he, if he had sued to enjoin the foreclosure and deposited the redemption money with the court?
But there was no need for him to sue to enjoin. The statute of limitations had passed. He would have had a
then it would have been an easy
perfect
case.
defense.
The problem that I'm having is that the certificate purchaser has never been part of this litigation. So we can't necessarily say that the certificate purchaser had no claims against the state or the county against your client. Can we at this point? And that's why if your client had waited and wanted to say, you can't foreclose, your lien is invalid.
He couldn't wait. The county was telling him, you have to pay this or you're going to lose the right.
There's going to be a foreclosure sale, and you could come in and challenge the foreclosure sale.
No, the foreclosure sale happened after. Excuse me. The plaintiff never received notice of any foreclosure action, even though it was an untimely action commenced 3 years after the 10 years had passed. He received no notice. So that he could have defended it is irrelevant to the fact that he elected to redeem under protest, and the county accepted his payment for that purpose.
But how has he been damaged? Assuming he owed taxes, the county collected the taxes, someone else had paid the taxes, that person may or may not have had a claim, but there's at least a colorable claim, and the county returned what the other person had paid. So that person presumably hasn't been unjustly enriched. The county now only has the amount of taxes that were initially owed. Where's the unjust enrichment?
There's unjust enrichment in two places, depending on where you see the money sitting. The county had the money twice over. That was the unjust enrichment. That it elected to pay it to the CP holder without even questioning his claim. And the reason it paid it is because of its mistake of law, which this court corrected in the previous decision in this case. Remember, you're saying, well, he could have gone into court, but as the county was interpreting, and as the county argued in the previous decision, it doesn't matter. The fact that the CP holder paid subsequent year's taxes means he can go on forever. So the county was saying, and the CP holder presumably would have been saying, well, see, I can bring my action any time. It was the error of law corrected by this court that clearly makes it inappropriate for the county to have paid the CP holder. Well,
it just says that the lien was invalid. It doesn't say that the certificate purchaser doesn't have some sort of claim against the county for that money.
Well, the CP holder is required to tender the certificate of purchase, and that must mean tender a valid certificate of purchase, or else invalidation means nothing. It's not only invalid, it evidences a void lien. It's a nullity.
There's other elements here, given that the statute changed after this certificate was purchased. It's found to be invalid, but that doesn't tell us whether the certificate purchaser would have had a legitimate claim against the county.
If you can say that ignorance of the law gives him a claim.
Well, it's not necessarily just ignorance of the law, but you could say the statute it might be unconstitutional if they had said it it gets rid of all liens after 10 years, and his lien had been purchased 20 years before the statute was adopted. Seems like he might have a claim of some kind.
Yeah, but this statute was enacted when the statute was enacted. It was after he purchased, but well before he gave him plenty of time to proceed. But if he had chosen
the statute provided to give notice to the certificate purchaser by having the county send out notice, and that wasn't done. So he may have a claim against them, and so they turned the money over to him.
But that's a separate mistake of the county. If notice was required to be given, then that's the CP holder can say, I have a claim against the county, not because I'm tendering a void certificate, but because I could have tendered a void certificate timely if I'd had notice. That's a separate issue. That might be something that I don't know whether the treasurer's disregard of that claim or rejection of that claim would fall within Fredina or not. But I'm sure this this cause of action does not. I hope the court will allow me some time to address the remarks of appellee's counsel. Appellants, yeah, appellee's counsel.
Mr. Stanley, we'll give you 2 extra minutes. Thank you.
Excuse me. May it please the court? Good morning, Your Honors. Oh, I'm sorry.
But Nathan, could you put 2 minutes on the appellant side? Thank you. Sorry, go ahead.
Just waiting to
and we'll give you the extra time that we're taking off now.
Thank you, Your Honor. Good morning, Your Honors. My name is Charles Trillinger. Sitting at council table with me today is Chad McBride. Both of us work with for the Maricopa County Attorney's Office, and we represent the appellee in this case, Maricopa County. The county is here asking that the court affirm the Superior Court judgment that, number 1, Maricopa County is the only remaining defendant in the case, and number 2, consistent with the holding in Fredina versus Maricopa County, the plaintiff has failed to state a claim against Maricopa County. As you know from reading the briefs, this is plaintiff appellant Span's second appeal in this case. In the first appeal, 4 of the 5 defendants were dismissed, and the court held that tax liens purchased at auction expired 10 years after purchase pursuant to ARS section 42-18208 capital A. The case was then remanded for further proceedings consistent with those rulings. On remand, then, the parties once again filed motions and cross motions for summary judgment, and the Superior Court Judge James Blomo ruled in favor of the county, as I've indicated just now. I think there are really 2 issues on appeal today. One of them is whether or not the Fredina versus Maricopa County case bars plaintiff's claims against the county. And second of all, whether plaintiff's unjust enrichment claim somehow avoids the Fredina decision, as you've alluded to a little bit ago. There are 2 additional issues that were briefed, but I don't think they're dispositive in the case. One of those issues was the attorney fees claim if the case is sent back on remand, whether or not Mr. Span would be entitled to ask for attorney fees under 12-348B1 from the remand forward. And another issue was plaintiffs, the subtax liens, whether or not the subtax liens that were rolled into the CPs are subject to the same time limitations as the original CP, whether or not they each carry their own 10 years time limit, or whether or not there's no time limit at all, because there's no statute that talks about what happens with subtaxes. Those 2 issues, I call them kind of secondary issues, because if the court grants or upholds the Superior Court judge's ruling, then those issues really are unnecessary. If the court remands the case, then those issues could be important on remand. What I think is not an issue in this case is whether or not the defendants who were dismissed in the first appeal can now be brought back into the case. That issue was already decided by this court and cannot be retried just because the case was remanded back to the Superior Court. The court's 325-14 memorandum decision says at paragraph 19 that for the foregoing reasons, we reverse and remand for further proceedings consistent with this decision. We take that language consistent with this decision to mean that the issues decided by this court can't be relitigated again on remand. Turning to the first key issue in this case, the Ferdina case, plaintiff wants to limit the case to just the label you put on the case, whether it's a tort case or something else, but I think it goes beyond that. And it's more of the conduct that gives rise to a cause of action. For example, the Ferdina case holds that when the county has no right to control the actions of an elected county official or his or her employees, then it cannot be vicariously liable for that official or his or her employees' actions. One of the citations in the Ferdina case that they cited 77 CJS Respondeat Superior, page 319. They also cited 57 Amjur 2nd regarding tort liability, and it actually uses the treasurer as an example. And what it says is that when duties are imposed upon a county treasurer, comma, or upon a board of county commissioners by law rather than by the county, the latter will not be responsible for their breach of duty or for their nonfeasance or misfeasance in relation to such duty, period.
So who pays? What would the plaintiff have been required to do? You sue the treasurer. The county has no liability for the treasurer's actions?
Right. Basically, Your Honor, there's one primary question in the case, and that is whether or not the elected official, in this case the treasurer or his employees, was that official and his employees, were they following a statutory scheme, which is, of course, set up by the state of Arizona, not the county, or were they following some dictate of the county? If they were doing their duties pursuant to a statutory authority, then the county is not responsible for that.
Precisely the argument here is that they were not doing what the statute requires, because the statute says the lien expires after 10 years, and so they were not just following a statute. So I'm not sure I'm following how the county would not be the party who's ultimately liable.
Well, I think that the distinction, Your Honor, is that it was the treasurer and the treasurer's department that was interpreting the Arizona statute in a particular way, and it appears, as a result of the first appeal, that the interpretation that they had was wrong. But the point is that they were following the dictates of the statute. Now, the statute itself was imperfect, and the state legislature, the folks that drafted the statute, apparently didn't think of that one issue, but the point is that the county treasurer was trying to perform the duties prescribed for them by the statute as opposed to duties prescribed to them by Maricopa County. So that's the difference, and that's why Ferdina applies, is that whenever an elected official or the employees are following the statutory mandate, then the county
doesn't the county require that? Don't they tell their employees that they need to comport with Arizona law? Isn't that an obligation that they owe to their ultimate employer, the county?
Sure, but as we found out, just because there's a statute doesn't mean you can, as we know from lots of different cases, statutes aren't perfect, and they have to be interpreted sometimes in some particular way. So at the time that this statute was being enforced by the treasurer, they were interpreting it the way they thought was correct. It later turns out the court said, no, you're incorrect about that. The statute of repose means that 10 years after the certificate of purchase was purchased, it expires.
So who would Mr. Spann recover from? They misinterpreted, so you have to sue the treasurer. You win against the treasurer. Who pays that judgment?
The payment would come from the county, but the payment shouldn't matter. Just like when you get into a car accident, if I get into a car accident, I drive down the street and I run into somebody, you sue me, you don't sue the insurance company that's going to pay the ultimate bill. So it shouldn't matter who's ultimately paying the debt. It should matter who's responsible for the action in the first place. So it was the treasurer, in this case, that was interpreting the statute. They were the ones, in fact, it's their duty under the statutes to carry out this, the process for how do you collect property liens when they're not paid, you put them up for auction, how do you do the CP liens, how do you do the redemption. So it was the treasurer that was following those statutes, and it was their duty to follow those statutes. So they are the proper defendant under the Ferdina case.
You said the second issue is whether a claim for unjust enrichment, whether the rule of Fredina can apply to a claim for unjust enrichment. And I take what you meant there is something you just implied, which is that I think it's the county that's holding the, I mean, arguably, that held or holds or held the money. So if anyone was unjustly enriched, according to the claim, it would be the county, not Mr. Schweikert.
Yes,
so,
Your Honor.
So why does Fredina have any application here, or why does Fredina have any application to a claim for unjust enrichment?
Sure. So I think there's two answers to that question, Your Honor. One answer is Fredina applies because the underlying conduct giving rise to the cause of action was the treasurer's application of the statute. So that's why it applies. For one thing, if we go beyond that, so in fact, I think Fredina is the perfect case to show why in a case like this one does it apply, even though it's not necessarily a tort. It's because it demonstrates that it's the conduct giving rise to the lawsuit which is decides whether or not Fredina applies. Even if Fredina doesn't apply, there is no cause of action here against the county or anybody really for unjust enrichment, because one of the elements of unjust enrichment is that somebody has to be enriched and they have to have retained that enrichment to the detriment of someone else. This money wasn't retained. It was sent right to the CP holder. So as you've mentioned.
Let's say the money was sent to the treasurer's cousin who didn't really have a claim for it. Even though the county doesn't have it, there still is presumably a claim of unjust enrichment. The county did something with that money for whatever its reason. Does it turn on the fact that there had to have been at least a viable claim that the money was owed to the certificate purchaser?
I don't know if it would turn on that, because, well, in this case, remember that the court interpreted the statute after all these things took place. So when the certificate holder got the money, that was the rule, that was the statute. It said that when a redemption is made, the payment goes to the CP holder, and then it's basically Mr. Spann has.
But his argument was that certificate was void. Under the statute of repose, it says there was no longer a valid certificate. So was the county required to give that money to the certificate holder? Well,
what he should have done to be able to make that, he was never required to pay the $102,000. What he should have done is he should have been involved in the foreclosure case in the first place. The reason he paid it, there was some mention about he didn't even know there was a case. Well, he obviously knew there was a case because he also knew that if he was served with the foreclosure action before he redeemed, he was going to get charged the attorney fees. That's the statutory rule. So what he did is he redeemed it before he got served with the lawsuit to avoid the attorney fees. Had he been served with the lawsuit, then he could have made those very same claims in this case. He could have said, hey, you can't pay that money out. This foreclosure has to stop because the treasurer is reading the statute wrong. The 10 years has expired. I shouldn't have to pay anything. The foreclosure should be stopped because the lien upon which the foreclosure is based is voided. So that's what Mr. Spann could have done. That's what he should have done in this case and didn't do it. And even after he didn't do it, when he filed suit against everybody else, he never sued the CP holder. Excuse me. To claim that the CP holder was somehow unjustly enriched. So he's missed his opportunities that he had to correct this without ever paying the $102,000 that he ended up paying to redeem the case.
So you're saying there's a significant difference between paying under protest and actually challenging a foreclosure action, paying the redemption amount under protest as opposed to challenging a subsequent foreclosure action?
Yeah, because by challenging the subsequent foreclosure, he wouldn't have had to pay at all. He would have been a party to the litigation, and as a party to the foreclosure litigation, he could have moved to enjoin the foreclosure, or he could have moved for a judgment in his favor, saying that hey, the foreclosure can't go forward because the statute has expired. Either way, he wouldn't have had to pay the $102,000 in the first place had he done that. But he didn't. I don't know why he didn't do that, but instead he chose to redeem it before he was served with the lawsuit, presumably to avoid the attorney fees that would have gone along had he lost the case and had to pay not only a redemption amount, but the attorney fees associated with the foreclosure action.
Do you have any knowledge of how Mr. Spahn paid the redemption fee under protest? What was the manner in which he indicated it was under protest?
I don't, Your Honor. I apologize. I heard your question, and I was wondering that, too. I don't know if there was some sort of written protest or verbal. I don't know the answer.
Does the record reveal anything about the manner in which the Treasurer's Office processes redemption checks such as that?
There is a process, and I think I don't think it made its way to the record, and so we didn't say much about how that process goes. But there is a process, and the way it's gone, and my understanding is there's an account, the money goes into this account and goes back out to the CP holders, but there wasn't much mentioned in it because it wasn't part of the record, Your Honor. The second, I think, major claim in the briefing anyway, and it wasn't addressed in oral argument here yet, but it was certainly in the written documents, is whether or not the defendants that were dismissed in the first case were properly considered dismissed as of the remand. We've cited lots of case law in our briefs that talk about that, and the fact that pretty much all of them say that an express declaration that the court intends a rule to guide the conduct of the trial court on remand is meant to be that. For example, in the TOVREA Tovria versus Superior Court case, the court said that the trial court is absolutely bound by the decision and mandate of an appellate court, and that it is not within the jurisdiction of the trial court to review the appellate court's determination. In the Kadish case, the court said that once an appellate court rules on a legal question, its decision is law of that case on issues decided in all subsequent proceedings in both trial and appellate courts, provided facts, issues, and evidence remain substantially the same. And in the Gila River Globe and Northern Railway Company versus Lyon, and all these are cited in the brief, it's settled law that all rulings made by the appellate court upon a first appeal become the law of the case and are conclusive upon any subsequent appeal. If plaintiff had been concerned about the motion for summary judgment ruling in the very first case, and he wasn't sure what the basis of the ruling was, he had a couple of different options he could have done. One of those options is he could have filed a motion for clarification, asking the court, hey, be more specific about what you're basing your dismissal on. That wasn't done. The other thing he could have done is in the initial appeal itself, he could have said, I'm re-raising everything that the court considered in the motion for summary judgment because I don't know which one is going to matter and which one isn't going to matter. But he didn't do that. And so this court properly dismissed the other four defendants. Basically everybody accepted the county in that initial appeal, and that should not be changed or reversed or reconsidered in this case. Those are the two primary issues, Your Honor. Like I said, there are two issues that were briefed in the case, and I'm not sure that they're going to make much of a difference unless the case is remanded, but I'll talk briefly about those.
Before you do, what do you think of the proposition which Mr. Stanley offered in response to our questions, that beyond unjust enrichment, there might be a claim stated for money had and received that a court would need to deal with?
Thank you, Your Honor. I'm glad you reminded me of that. I wrote that down. I remember looking at the cases that he cited when I saw that. My understanding from reading those cases is that at one point in time there was a claim called a sumpsit something, which then turned into a claim for money hadn't received, which then turned into a claim for quantum merit, although that claim is still available. My understanding is that unjust enrichment is just basically the modern version of the money hadn't received claim. That's my understanding anyway.
So your contention would be that even under money hadn't received, you'd need to deal with the elements that we recognize today to be required to prove a claim for unjust enrichment. And if those elements can't be proven, then it doesn't matter how you characterize the claim.
Yeah, exactly, Your Honor. And another point is that the court denied the trial court denied plaintiff's his own motion for summary judgment on that claim of unjust enrichment. So granted the county's claim for motion for summary judgment for the under the Ferdinand case and denied plaintiff's claim under unjust enrichment, and both of those decisions were, of course, in our opinion, correct. We think Ferdinand applies to those opinions, or Ferdinand applies to that claim anyway, because the action that gave rise to the claim is still the statutory duties that were being carried out. But even if it doesn't apply, there is no claim against the county for unjust enrichment.
But you are suggesting that the county had an obligation, that the redemption statute dictated that the county pay the money even if the lien had expired, that was unrelated to whether there was an expired lien?
At the time that they paid the money, they didn't know that the lien had expired because the statute wasn't clear on that. And I think that's the thing. We can now go back in 20/20 hindsight say that the treasurer made a mistake because they paid out this money for the claim that had been void. But at the time they paid the claim out, they didn't know it was void. And in fact, they were of the position that it hadn't been voided for a couple reasons. One of which was what's that?
The subsequent payments.
Yeah, the subsequent tax payments. And then the other reason was that before there's another statute that says before a lien matures, the county has to give 6 months notice, or the treasurer has to give 6 months notice of that, and that wasn't done either. So at the time that happened, there was no law that said that the treasurer that would have said the treasurer's actions were wrong or gave rise to some cause of action. It wasn't until this court decided what that 10-year rule meant that we now know how to interpret that any certificate of purchase purchased at auction expires 10 years from the date it was purchased. And in fact, now since 2016, CPs that are purchased in subsequent years are there's a new CP issued for subtaxes that are paid as well.
What do you mean by that? I mean, what's the effect of that?
Sure. So,
new lien, the liens are maybe foreclosed year by year. Is that the point?
So, thank you, Your Honor. In this case, there was a CP purchased in 1995 for 1993 taxes. The CP holder then purchased the 94, 5, and 6 taxes. Those tax payments were rolled into the 1993 certificate of purchase. After 2016, every time you buy a new subtax, you get a new certificate of purchase for that.
Is that a change in the statute, or is that just the?
It is a change to the statute. Yeah, it's Section B, I think now basically it's in 2016 you're buying tax liens from 2014. So.
And a subtax means?
A subtax means, thank you, Your Honor.
Subsequent tax?
Yeah. So in this case, for example, in 1993, Mr. Spann didn't pay his property taxes. Those property taxes were sold at auction in 1995. To protect the position of the person who bought those taxes, they don't have to go through another auction process in 94, 95, and 96. The person who bought the 93 taxes can just pay the 94, 95, and 96 taxes without going to auction.
But if they do,
they do it all the time, so that nobody has to come in and there's multiple people trying to foreclose on that property.
But now they get a new lien.
Yes, Your Honor. So,
and if they've waited longer than 10 years after the first lien, what happens to that one? Is that one disappears, and they now only have liens in the amount of the subsequent purchases?
Yes. So the subtax statute still doesn't have a statute of repose for subtaxes, but presumably they would expire 10 years from the date that the subtax, in other words, 10 years from the date you get a certificate of purchase is when those would expire as well. But in this case, the 94, 95, and 96 taxes that were paid, the subtaxes that were paid, were all part of the 1990.
Right. But in your new scenario,
yes,
what happens? Okay, I buy a tax lien for years, 95, 96, and then I pay every year thereafter. I want to foreclose in 2010. So my claim, so the lien as to the 95 tax is void, but what happens then?
Well, if
Yeah.
you don't foreclose
Yeah.
within 10 years of the date, then the lien becomes void, and then the property owner presumably just gets the property without having to do a redemption process. The taxes were still paid by the CP holder, so
You have to work it out, and then I take it an unjust enrichment claim at that point.
presumably, yeah.
Okay.
Yeah, but that's why that issue may be important. If the case is remanded for some reason, we know that the 94, and I apologize, I'm going over my time, the 94, 95, and 96 taxes were rolled into that 1993 CP. And so one of the issue, if it gets remanded, and we're not saying it should, but just if it does, does the 94 tax lien that was purchased expire 10 years from the date it was purchased, and the 95 one and the 96 one, or do those all expire at the same time that the 93 one expired, which
Got
was
it.
2005, if that makes sense.
Okay, thank you.
Thank you for your time, Your Honor.
Thank you for the additional time, Your Honors. First of all, the alternative of redeeming as opposed to appearing in the foreclosure action, which he learned about but had not been served. I think somebody saw it in the paper or something, told him. In any event, he learned about it, and he therefore had the alternative, Mr. Spann did, of either redeeming or appearing in the action. He chose the alternative. There's a legally available alternative of doing redemption. Actually, the treasurer's office then told him, well, you have to do it within, I think they gave him 3 days or 5 days or something like that. I remember seeing documents about his written protest, payment under protest, but I have not addressed that because, as I say, the court in its previous decision said he had paid under protest. So I take that to be law of the case. I mean, it's really upsetting that the county is simply cavalierly asserting for the first time in this argument, oh, of course the county would really be liable. Of course the county would pay if you sued the treasurer, you sued Mr. Schweikert, got a judgment against him. Of course the county would be liable for what the county is describing as his tort, his unauthorized taking of your money. There's no law of any kind supporting that proposition. There's no law saying that elected county officers who are sued and get judgments against them for their personal actions, if this is what their argument is based on, get indemnity from the county. Just made up out of whole cloth here today. And I'd like to read footnote 2 on page 2 of the reply brief. Dunn versus Berks County, 114 Atlantic 2nd, 310, a sumsit to recover excess payments made to county treasurer. Held, treasurer acted as fiscal agent of the county, and therefore county be sued and held liable to refund overpayments. And actually there's thousands of cases that say a sumsit to recover overpaid taxes, and the entity, the government entity that's getting the taxes, is liable to pay it.
All right. Thank you for your time. Thank you to both sets of counsel for your briefing and for your argument. We'll take the matter under advisement, and we will issue a decision in due course. Now we adjourn.
Thank you.